Well, Alex, thank you very much for coming on today.
Thank you for having me.
How are you doing?
Pretty good.
Pretty good. Busy?
New year. Busy. Yeah, we've had a really busy last year. But this year, keep going.
Would you say it's improving over last year or getting busier, less busy?
For some reason, now I say for some reason because it's not really following the market, we are busier than ever.
Really?
Yeah.
Any idea why that might be? Or you guys are just that good?
Honestly, no idea. I mean, my colleague Mark has built a name for himself, so he's constantly on the go and we're just collecting more and more business.
Nice.
So that's probably why. I mean, I joined the firm about 2 years ago. So, my business has also added on to it. But
That's awesome.
We're doing well.
Awesome. That's great. Great to hear.
Yeah.
How did you get into this business and a little bit about yourself? First of all, how did you get into this?
So, I mean, honestly, in law school, I didn't think I'd be going into residential real estate law.
Okay.
I always wanted to do, something more exciting, to be honest. I wanted to do something like entertainment law. But seeing as my family's in residential real estate, just the real estate business in general, kind of seemed like the natural progression. I was always interested in real estate in general. And so going into this when I became a lawyer was kind of the natural choice.
Nice. That's awesome. And no regrets, I guess?
Not yet.
Not yet?
Not yet.
So what? Just maybe tell us what you do. So you do specifically real estate law, any business law, or just specifically real estate?
Specifically real estate.
Real estate, okay.
We're quite specialized in that. So we focus on residential real estate. We're starting to move into commercial, but we're quite a high volume based law firm. We close around 100 transactions a month.
Nice.
Anywhere between residential sales, purchases, but also pre-construction purchases and assignments as well. That makes about 30 and 40% of our deals.
Cool. What's the name of your firm? Sorry.
Legalclosing.ca.
Legalclosing.ca. Okay, awesome. And you guys are based. You have an office here, but you're based somewhere else.
In Toronto, yeah. We're around St. Clair and Christie.
St. Clair, Christie. Awesome. And you service GTA, all of Ontario.
All of Ontario.
Nice.
Pretty much.
Okay.
I'd say 90% of our deals do close virtually, thanks to COVID.
That's awesome.
So we do a lot of virtual closings, but if we have an elderly client that would like to come in, or just anyone in general who wants to meet us in person, we do have that office there as well.
Sure. Okay. Maybe we'll segue into this. So in terms of the real estate transactions, we have a lot of buyers and sellers that are listening, but maybe we take it from the buyer point of view. Maybe some elements overlap with the seller, but just in terms of the process, if you could elaborate on the process of what a real estate lawyer does in terms of helping close a transaction. Maybe let's keep it on resale for now, because I'm sure pre-construction is a little bit different.
Yeah.
But maybe let's take it from, real estate agent side, deal is sold firm, deposits in, everything is good, we're firm and bound, and now we've sent you the documents, you're representing, let's say you're representing the buyer. What kind of process happens behind the scenes with the lawyer?
Yeah. So, for example, if it's a condo, our work actually starts before the deal is firm. We do the status certificate review.
Right. Okay.
So a lot of condos, actually all condos have a status certificate, and it's pretty much the overview of the health of the corporation, right? Because if you're buying a condo, you're kind of buying into a corporation. When you're paying your monthly condo fees, that's kind of buying into it. And so sometimes there's risk, sometimes there's litigation against the condo. So we do that kind of background work before the deal becomes firm. Right. Then the deal becomes firm, we get the agreement, and we start the file. So technically speaking, it is a legal requirement to have a lawyer close your deal in Ontario at least. One of the very few provinces that has that. But we help, we're actually a very hands-on law firm. We handhold all the clients through the closing. But in the background, what happens at the very beginning of the file, first thing, we obviously send our introductory email, we introduce ourselves, and then the real work happens in the back end. So we have what's called the title search date, which is in the agreement of purchase and sale. Obviously, everyone ignores that. The purchasers ignore that because they don't really know what that is. No. But that's kind of what we start with at the very beginning. The title search happens approximately 2 weeks before closing.
Right.
So from the time that we get the agreement until that title search date, not much happens.
Okay.
Other than, we get into contact with the seller's lawyers. Then some back and forth happens. We send our letters. And then technically the seller's lawyers are the ones that send us the math.
Okay.
We call them the statement of adjustments.
Okay.
That is where we find out exactly how much is owed to the sellers on closing. And then we also have the client provide our information to the mortgage broker, the bank, or whoever's providing the mortgage for the actual purchase. That also happens all on the back end. It's funny because I do get a lot of calls saying, okay, so what's the update? And the updates, well, we're working on it. And there's a lot of back and forth, but we're always happy to discuss that with the clients. So once the numbers are in, and what is also called the mortgage instructions are into our office, that's kind of when we start to communicate with the client again, saying this is the math, this is the amount of money we need on closing.
Cool.
And then about the week of closing, we also hop on a call with the client.
Okay.
Of course, there's law society requirements where we have to get to know our client, verify, who's going on title, how they'd like to take title, whether that's through tenants in common or joint tenants, if there's more than one purchaser. We have a lot of those discussions, and not a lot of lawyers actually meet with our clients, but that's kind of something that we aim to do with all of our clients. And then we explain what happens on day of closing. And something that also comes up on these calls is the topic of title insurance.
Right. Because
a lot of lawyers, they won't even touch a file if the client doesn't agree to get title insurance.
Right. And it's only, I think, like $500, something like that.
Depends on the purchase price.
Okay.
Yeah. So if you're getting a condo for, let's say, $500-600, you're looking at maybe a title insurance around $300 to $400.
Okay.
Yeah.
And what does that do for you? How does that protect the purchaser?
Yeah, so I can actually explain what happened before title insurance.
Sure.
Before title insurance, lawyers gave what was called a lawyer's opinion letter on title. So they did all the searches themselves.
Oh, wow.
And that is not just one, expensive, but two, it takes a lot of time to do those searches and get the results back.
I can imagine.
And so I guess somewhere along the way, title insurance was like, hey, let's help you out and take that pressure off and let's insure over it. So, I mean, the one thing that comes up most often is tax arrears. Okay. So if, for example, a purchaser purchases a property and let's say the previous owner didn't pay their taxes and it comes up, we obviously initially approach the seller's lawyer saying, please pay us back. But if that doesn't work, then title insurance covers it. We go for a title insurance claim, and that kind of covers those arrears.
But that would be discovered before closing, though.
The search is done, but nevertheless, the seller's lawyer sometimes isn't even aware of the arrears. Sometimes what also comes up is the vacant home tax. The previous owner didn't elect that in, I believe it's February of every year.
So they didn't fill out the sheet, the questionnaire.
Exactly. They didn't submit that declaration. Again, it's quite new, the vacant home tax.
That's just Toronto.
Exactly.
Just Toronto.
Yeah. And so all law firms are trying to navigate how best to, look that up before closing. But nevertheless, that's where the title insurance claim comes in. So
I guess more of the story is don't be cheap, get title insurance.
Exactly.
Yeah. For peace, you're already spending hundreds of thousands, if not millions, on a property. What's an extra $500, $1,000?
100%. And it does save you money because, again, like I said, a lot of the separate searches will cost you more.
Right.
And a lot of lawyers also won't even touch a file if you're not getting title insurance.
So is title insurance, it's a separate body that governs over it? Is it a government organization?
No. They're individual insurance companies.
It's insurance. Okay.
Yeah. So there's Chicago Title, FCT.
Okay.
And also lenders. If you're getting a mortgage, it's almost always a requirement to get title insurance.
For sure.
Both lender's policy and owner's policy.
Okay. I know. Actually, I wanted to go back. We were talking about the title search date.
Yes.
On the agreement, purchase, and sale. So, what is that part of what you're looking for in that title search date?
Yeah.
What exactly are you guys looking for on title?
Yeah. So there's actually it depends on the policy. When you're getting title insurance, there are mandatory searches, and one of them being the taxes.
So
property taxes.
arrears and taxes, property tax.
Yeah.
What else is another common one?
Honestly, I haven't
There's
done.
a lien on the property without count.
So once we do the actual title search, we actually pull up the parcel. So any kind of encumbrances that are on title. So if there's any easements
Okay.
on there, most easements do, run with the property, and
Yes.
there's not much you can do. For
Sure.
example, there's a Rogers line running across the property, and any mortgage that's on title.
Okay.
Then we, in our requisition letter, that's a letter that we send the seller's lawyers to kind of instruct what is to be done before closing. That is obviously discharge the current mortgage.
Okay.
Because again, you can't take title with that
With a
mortgage
current
on there.
Right.
Yeah.
Okay. Okay. No, that makes a lot of sense. You definitely don't want to take over someone's mortgage. So
Exactly.
Yeah.
Exactly. Yeah.
Okay, that's awesome. So in terms of the closing day, how does that kind of work out? The funds are transferred, title is transferred on that exact closing day as well?
Yes.
Okay.
Yeah. So funds are typically transferred either the day before or the day of closing.
Okay. Oh, even the day before. Okay, cool.
Yes. If that again, it's. I mean, I haven't seen it being done the day before, but I think it mainly is because the banks are really last minute with these kinds of things.
Interesting.
So if the mortgage funds come the day before, absolutely, we're prepared to send the funds to the sellers
Okay.
that day. But usually it's the bank that kind of waits till the very last minute
I can imagine.
to send our trust account the funds to then allow us to fund the
Right.
sellers.
Right. And I think we've spoke about this offline, but I think there have been some situations that you dealt with, and I think I had one too where going back to the mortgage instructions, they were never followed. So there was a holdup on giving the funds that day. Have you ever had something like that happen where the funds were not being released by the mortgage company?
Yeah. So sometimes, I mean, I actually haven't dealt too closely with what happens on the back end. But we receive instructions at least 5 days before closing.
Okay.
Sometimes we do receive them on the day of closing. And that's when our clerks are running around
All
like
hell breaks
crazy.
loose.
And we're putting together a list of items that we need from the purchasers before closing.
Right.
Sometimes that's a new insurance policy. Sometimes that's different information with regards to any credit cards or stuff like that. But a lot of it is done through a mortgage broker. If you're getting a mortgage broker, they also help the process.
Right.
But I honestly can't even tell you what the delay is from.
It's from, okay.
Sometimes.
Okay.
Not sure if it's lack of confidence on the back end of banks, or it's just I don't know. Maybe it's their requirements to even receive a mortgage these days.
Yeah.
And the standard might have increased. Sometimes there's more red flags that come up closer to closing.
Sure. We've had it where, okay, so I don't know if it was, because we met at a breakfast meeting when Don hosted at
Yes.
Brokerages. I don't know if it was that same date when you were there, but there was a mortgage, it wasn't a broker. He worked for TD.
For TD, yeah, I remember.
That John, I forget his name.
Yeah.
But he was mentioning, yes, I think, yeah. He had mentioned that sometimes people can get into trouble using a broker in certain cases.
Yes, it's kind of like the middleman.
Yes.
And you're kind of playing, broken telephone sometimes.
I think the example he gave was the ball was kind of dropped, or in the final commitment letter or something along those lines. The bank said, okay, you need to do X, Y, Z, and that was never communicated to the buyer. So then these issues are arising on the day of closing.
Yeah, they're kind of throwing blame back and forth.
Sure. Sure.
But it's.
In your experience, do your deals, the deals that you handle, are they smoother when there's a broker involved or through the bank directly? Do you notice any difference?
I haven't.
You haven't
recently.
Okay.
I think people really like having a mortgage broker. If there's deals to be had, maybe they have,
Right.
The sway if they want a better deal on their rate.
Right. Well, they have access to different banks, different products.
Totally.
Yeah.
And I think they also just like being handheld as well.
Of course.
I think a mortgage broker will explain your mortgage better than a bank would.
Yeah, you'd hope so. Yeah. You'd hope they have some value, right? Yeah.
Exactly.
Yeah.
Exactly. I mean, we have clients come to us quite frequently as well, where they say, I haven't really read or been explained this agreement, the mortgage commitment, very well. And so that's kind of where we step in sometimes to at least obviously explain the legalities, but the numbers too, sometimes they are
not clear on.
Exactly.
Yeah. Well, I think communication is a big thing for my business, your business. We're intertwined that way. To your point, we have a lot of clients that complain that come from us from different experiences, saying that they were never explained the agreement, purchase, and sale.
Yeah.
Not to say that we go every single line, but we definitely cover all the important things. And title search date is one of them, actually.
Yeah.
Yeah, that we go over. Yeah.
Perfect.
Just so they're aware of it, right?
Absolutely. And then we have a lot of nervous first-time home buyers.
Of course.
Right. This is the biggest purchase you can make in your life, right?
Yes. Yeah, it is. It is. And yeah, no, it's good because it's good to have a lawyer that can communicate and get back to you in a timely manner. And I think it's important, especially when you're nervous about something, to have that reassurance.
Absolutely.
Because, if you're not hearing back from anyone, it's just a void, and then they're left with their own thoughts and a bunch of what ifs.
And that's kind of what we realized in our office. And from the get-go, we actually don't even have a secretary answering our calls. When we give a client our phone number, it is our cell phone that rings.
Awesome.
So they reach us directly, and that's what they also appreciate about our service as well. Because again, those nervous clients have that comfort in knowing that we'll answer our calls.
Right. So would you say that's the number one thing that your clients come back to you for, that communication?
100%. Yeah. We also have immense transparency. Transparency in our prices too.
Okay.
The prices we quote is a lump sum. There's no disbursements at the end.
Okay.
Some people assume that your lawyer will tack on a lot of disbursements, which most do.
Okay.
But
You're a flat fee.
Flat fee.
What it is what it is.
Exactly. What we quote to you at the beginning is what you'll see on the trust ledger at the end.
Sure.
And absolutely having the direct communication with us.
Okay.
And customer service.
Nice.
Yeah.
I wanted your opinion on something. I don't know if you can give me an answer on this, but obviously you deal with our REIA realtor forms all the time, right?
Mm-hmm.
Agreement, purchase, and sale. In your opinion, I mean, I guess they're written by lawyers, but are they a good document? Are they sound? Are they always legally binding? Are there any instances where maybe the agent or the other agent does something to the agreement, purchase, and sale that makes it not legally binding? Have you ever experienced something like that?
Yes and no. I mean, I'm on a lot of these real estate lawyer platforms on social media, primarily on Facebook, and a lot of people are complaining about them. Not that, anything written in them, especially if you use them properly, makes it invalid. But just because, the market and the law is so fluid, I guess there can be a lot of changes done to them to make it better. Not just, I don't think there's a risk in, making it invalid. You just got to be careful. We have a lot of agents last minute calling us to draft certain clauses to protect, I guess, certain scenarios that happen. But as it stands, I honestly don't have an opinion. It's been working. Can they be better? Absolutely.
Sure. Okay. Have you ever seen an agreement, purchase, and sale, APS, that is not legally binding?
No, I mean, there are scenarios where people have tried to get out of agreements and just simply by, making small amendments, and then someone misses an irrevocability date. But
can you get out of that if one little thing wasn't initial? Does that give you legal grounds?
No. Again, this is it's a much longer conversation, but we have a lot of agents calling us saying, this didn't come in on time, and again, you have that time is of the essence clause in the agreement that really makes things vitally important and clear. Yeah.
Okay. Actually, that was another thing I wanted to ask. I believe I already know the answer to it, but just to be nice for the audience. So, agreement, purchase, and sale, buyer and seller, it's signed, confirmation of acceptance, acknowledgement. Let's just say it's a firm offer, just for argument's sake. But the deposit is never delivered. Is the paper, is it still legally binding? Do you still have a deal?
No, you do not have a deal.
You do not have a deal? No.
The time is of the essence clause. If the deposit is delivered late, that is no longer a valid agreement. However, there's certain scenarios where you could, for example, let's say the seller does accept the deposit late and still continues to act like it is a valid agreement, then if it ever goes to court, then I think the court would find that it is a valid agreement still. Interesting.
So okay, let's expand on this, because I was under the impression of the opposite, actually. So I'm glad I asked you. So I buy property and I never end up delivering the deposit. So the seller cannot sue me for not fulfilling the contract?
When
Can the seller sue me for, say I'm the buyer and I signed the agreement of purchase and sale, but I never delivered the deposit? Can the seller hold me liable?
they could, of course, they could also just keep. Oh, well, if you never deliver the deposit again, you don't really have.
But would I be in breach of contract?
You would.
Oh, I would. Okay, I still would be
be
in breach of contract.
Yeah.
Okay. That's what I understood.
Yeah, but
Okay.
again, they also,
But you don't have a deal,
practically
really.
No.
Okay. But so if that were to go to court, would the seller win, in your opinion?
I don't litigate, so
Okay.
it would be hard to say.
Okay.
But again,
As what we can say is it is a breach of contract.
yes.
So really, you shouldn't be, and this is what we say to our clients: you should not be engaging in an agreement purchase and sale unless you absolutely have intent on.
And then I think something that agents also miss is that they, for example, don't understand that signing the agreement within the irrevocability period is a requirement, but there's also a requirement to communicate that by that irrevocability period.
Communicate that the period exists.
The sign, actually, exactly, and that the agreement has been signed. So let's say it's irrevocable until noon.
Right.
You sign the agreement by 11:55, but you don't communicate it until 12:05. That is also invalid.
I see.
Right.
Okay.
So
Kind of like in bad faith. Is that
not
fair to
even
say?
in bad faith. Just again, that time is of the essence clause.
I see.
It's saying, if the irrevocability is until noon, it is until noon.
Right.
And to have a valid contract, you not only have to have acceptance, you also have to have communication of the acceptance.
Right.
So it's that communication portion that is sometimes missed as well.
Okay. So an example of this. So say, for example, I have an offer on the table. The irrevocable is, it's 12:25 right now. It's irrevocable till 12:30. My client signs it at 12:26, but I don't communicate it until 12:45. It would technically not.
That's a no-no.
It would technically be outside of the irrevocable period.
Exactly.
So if they wanted to, the offer could be null and void.
Exactly.
Interesting. Okay.
Yeah.
Okay.
Then you'd have to, revive it or draft a new agreement. Again, some purchasers or sellers, whoever wasn't able to make it on time, they want to sell it. So
Yeah,
it's
these
not
are
detrimental sometimes.
Right.
But again, if you're in a multiple offer situation and there's a new deal that just came in,
right.
They're going to want to walk
No,
away
exactly.
from that anyways.
I've used that to my advantage because I had a client that wanted to put in 2 offers. Mind you, it was just for a lease, but still, and I just staggered the irrevocable dates.
Yeah.
And we got the deal done with the second offer, but many hours later, on that first offer, the listing agent gave me a call saying, "Oh, I'm just on my way home. I'm going to accept your offer when I get home." I'm like, there's no more offer.
Too late.
Too late. Exactly. And I feel bad because I think she lost the listing because of that. And I communicated it to her. I said, "Listen, this is irrevocable," and she just never got back to me.
Yeah.
And it was too late.
And I honestly think that's why they put the time is of the essence
Right.
portion in those agreements, because time really does matter in these deals.
Okay. Also, another thing I want to ask you. So we see sometimes we get, and I wanted to ask you about this after, in terms of like bank foreclosure, where like usually the private lender has their own set of lawyers, and they've like scratched out certain lines in the agreement purchase and sale. They've crossed stuff out. They've added stuff in. Do you have a comment on that? Is that really necessary? I guess it depends on the situation. Or
So you mean when a lender takes over the?
This was just that example, but I've seen it where lawyers, like the client's lawyer, for example, let's just say the seller's lawyer has taken my agreement purchase and sale and made agreements to like made amendments to the standard
like
clauses.
mm-hmm.
Yeah, either crossed them out and added their own verbiage in there. Is that, I guess that's permissible?
I haven't seen that often, but
Okay.
It's an agreement, right? If you're signing off on it and you're initialing any changes, then you can agree to that.
Because at the end of the day, if both parties are willing, then that's all good. Okay,
Yeah.
Cool. Okay, no, I was just curious about that. You're right. You don't see it that often, but I have seen it. I've never personally done a deal with that, but I have seen it in schedules and stuff.
Yeah, again, because some standard clauses are there to benefit the seller, some are to benefit the purchaser. So it depends on what side you can be crossing those off.
I see. Okay, and that's totally cool then, as long as both parties are aware and sign.
Yeah.
Okay.
Again, it depends, because some of them are quite vital to the agreement. But if it's, for example, in the condo, I see that clause that states that they're representing and warranting that there's no special assessment on the condo.
Okay.
I've seen that crossed off.
Oh, really?
Yeah.
And is that not legal?
No, of course it is.
It's not, but it's just a red flag.
It's no, I'm just saying that it's something that I've seen done.
Oh, I see.
That
Okay.
would again benefit the seller because they don't want to say that there hasn't been
They won't
special
make a
assessment
guarantee.
either way.
I see.
Yeah.
Okay. Interesting. Yeah, that's why going back to the status certificate, very important to review that.
100%.
Yeah.
And again, we're quite particular in our reviews. A lot of the time, again, one of the main things we look for is that there's no significant litigation against the condo because there is potential that the condo is a CMHC blacklisted.
Okay.
That would then in turn make it more difficult to get a mortgage. And so that is, for example, one thing that we look for in the status.
Okay. Do you know what the criteria is to have a condo blacklisted? I mean, I would imagine it's not just one lawsuit.
No, honestly, on our end, if we see, I'd say anything over $2 million or multiple pieces of litigation that are not in small claims court, we say just to be on the safe side, go to your bank and ask if they're
okay with that.
listed. Exactly.
Okay.
And then your bank will be able to provide you with that information.
Yeah, actually, Michelle and I had a client a couple years ago that was looking to buy a building in Toronto. I forget the exact building, and I won't mention it anyways, for obvious reasons. But yeah, so we looked at the status. It was reviewed, and I mean, it was obvious. It's very easy that format, but obviously we got the lawyer to look at it, and yeah, there was some litigation. It was a new building, a couple years old. So I believe the condo corp was suing the builder over some whatever it was
deficiency or whatever.
You're right.
Yeah.
And it was in like the multi-million dollars. So we just
so people assume that it's just the problematic litigation that's where someone is suing the condo, but even the condo is suing for deficiency. If, for example, the condo is not successful in recouping those damages from court, you also have to remember that, okay, then it's the condo and all the owners that are responsible for those deficiencies. So if it's multiple millions, then it'll end up coming back to the purchasers.
Right. And it's fair to say that in a new condo, the reserve fund is fairly low.
Yeah.
So you're most likely not going to cover
that too. And I also find that condos tend to underestimate the condo fees at the very beginning when they're quite new condos. You see, your monthly condo expenses at like $400, $500.
Yeah.
And then you see the next 3 years, they jump.
Sure. Well, I think because the builder sets them and then, they're trying to be competitive in the market. No, that's a great point. It's true. We've seen it. Yeah. I think now the average is like 50, 60 cents a square foot, but I would argue, it ends up being a little bit more than that. Yeah. Because on 50 cents square foot, 1,000 square foot condo would be $500 a month. That's not really what we're seeing. Yeah. We're seeing maybe a brand new condo, but we're seeing like, well established, few years old, 600, 650 a month for the good ones. But then we've seen, you get into these really old condos where the value is now affected because the maintenance is, well over $1,000 a month.
Really?
Yeah. Yeah. It's crazy. But I mean, people need a place to live.
100%.
It's a little bit more affordable.
Yeah. Short
term, but long term, you're paying for it. So
yeah, listen, people are still buying them. So
yeah. Oh, of course.
It's not too big of a deterrent.
Yeah. Actually, I wanted to move. So that gives no, it's not. It's true. I wanted to move into the pre-construction market. I know you do everything in terms of real estate law, but I think you do have some experience with pre-construction. What has your experience been? Because I know last year was a very tough year in terms of that. I've had just about a dozen or 24 conversations with people that have been in a situation where they've bought this pre-construction product,
can no longer close,
or are under the impression that they can just assign it and get back their deposit at least. We had a client purchase something out west, and it's worth, it takes away his full deposit and then some. Yeah. So we're seeing like there's negative equity. We're seeing, they have to give up their deposit and maybe pay 30, 40, 50,000. Can you just talk about your experience on that? How you guys, what's the kind of plan of attack? If I come to you with that situation, are you guys able to help?
Yeah. So, I mean, we also have 5 of these calls
because there's not much we can do. If there's no equity in the house, our advice, and maybe you can comment on this, is if you can close on it, we encourage you to rent it out and hold on tight.
Absolutely.
Yes. But if you can't, then you may have to look at cutting your losses.
Yeah.
Is that fair on your end?
Totally.
Yeah.
So the first option obviously is finding a way to close.
Any means necessary.
The other best option is to assign. Of course,
Okay.
the assignment market is dead.
Yes.
We've seen assignors actually paying the assignment purchaser for them to take over the deal.
Right.
So we've seen a lot of that.
What's the highest amount you've seen where they're paying the buyer to take it over?
You know what? I've only seen it twice.
Okay.
I think it was around 30,000, 40,000, where they had to tack on
Plus
to
they lost the deposit.
plus they're giving up the deposit. Yeah.
Wow.
So that might have made financial sense because again, when you're not able to close, the other option, of course, is asking the builder for a vendor take-back mortgage.
Okay.
That's one option. Of course, again, that might just be delaying the inevitable.
Does that happen in your experience?
Yeah.
The builder will give a VTB?
Yeah.
Okay.
Yeah.
Okay.
Again, because the builders are bleeding too. They want people to close. So some are willing to negotiate in that sense. We've also magically actually just recently convinced a builder to reduce the purchase price.
Wow. For all the units or just that one
No,
specific?
just this specific
Okay.
client. Because again, the appraisal came down, I think, 350,000 under.
Oh my.
And so they didn't have that cash. And so some builders are willing, especially because, the alternative for them is to resell it at even less.
Right.
And so we've seen that happen. It is very rare. But nevertheless, we take the client's instruction and we ask them, or we pass on their instructions to the builder and request that.
You try to make the best out of the situation for them. Right.
Exactly. And then, of course, the last option is to not close, which, again, I think we were talking about this before. It's not illegal to break a contract, but
Right.
it is a business decision. So
Right.
if you have spoken to your mortgage broker and really just does not make sense to, lend even or borrow even more, then maybe breaking the contract and not closing is another option. But
Right.
again, the ramification of that is, one, you lose your deposit, and two, you might get sued for the delta, meaning the original purchase price versus the resale price
Right.
at that current market.
So I guess an example would be, so if the condo, you bought it for 600,000, it's only worth 500,000, that delta would be 100,000.
100,000,
Okay.
yeah.
Cool.
Plus
you lost your deposit. Let's just say for easy math, it was 100K down. So you're losing 200,000 minimum, maybe plus some lawyer fees, some legal fees. Is that fair to say?
Exactly.
Okay.
Yeah.
What, in your experience, I guess every builder is different, but in general, are builders going after buyers?
We've seen some statement of claims coming into our
Okay.
office. Yeah.
Okay.
Again, not a lot, but then again, they also have 2 years to do that.
Right. Okay. Okay, that makes sense.
Yeah.
2 years from the date that the
They do
agreement
not
was
close.
signed. Oh, from when they do not close.
Yeah.
Okay. Okay. So that could be
Or when they've defaulted, because again, sometimes default happens where they miss a deposit rather
see.
than not close on closing day.
Oh, okay.
Yeah.
Okay. Oh, that can be seen as a default.
Yeah.
Okay. Yeah, actually we had a client that was in that situation where they missed a payment. And I think they ended up deciding to
Walk
go-
away.
No, I think they decided they're gonna hold it. They're gonna make the payment and
Okay.
continue.
Yeah, because listen, like you can get a letter of default from the builder, but practically speaking, they, like I said before, they want to close. So if you're
Right.
late on a payment and you say, hey, listen, like I'm really struggling right now.
They'll work with you.
They'll most likely work with you.
Okay, that's fair. I mean, like you said, everyone, they're trying to close too. It hurts their bottom line as well.
Totally.
So, okay, that's not so bad. I was going to ask before, do you see it more the builder caving more, or have you also seen the banks helping out as well? I don't know if you have experience with the bank side of things.
Not necessarily, but I have seen in my experience in the last couple of months 2 projects canceled, and the builder went into receivership. And
What does that mean again? Just what is receivership?
Receivership is when the bank takes over.
Oh, okay.
Yeah.
Okay.
So again, technically the project ceases to exist, and
interesting.
the lender takes the position of the builder. So practically speaking, if you're purchasing from a builder who has gone into receivership, a lot of the times it doesn't really mean much because again the bank takes over. Sometimes they elect a different builder to take over the project, and it's business as usual.
So they will complete the project.
They will want to complete the project. 'Cause that's the only way that they'll
Make it out.
exactly make back their investment.
Will that only happen if like the shovel, like the ground's been broken, or that
Yes.
can even happen? Okay.
Most likely,
Okay.
yeah.
Okay.
And then, of course, the other option is that they end up not closing, and then you kind of look to Tarion for getting back your deposit.
Right, but I don't think they cover the full deposit, do they?
Depends if it's a condo or a freehold.
Condo, freehold, okay.
Condo, most likely, because again, if Tarion doesn't cover the full portion, they're required to actually get private insurance to cover whatever portion wasn't held in trust.
The builders.
Yeah.
Required. Okay. Okay. Interesting.
Yeah.
Yeah. Do you have any opinion on Tarion warranty?
No.
No. Okay. Okay. No, fair enough.
Honestly, I haven't seen it actually in functioning. I know I've again those two clients that purchased within those projects that went into receivership. They just ended up applying for the Tarion deposit back.
Okay. They got it back?
Not yet.
Oh, okay.
I think it's a longer process. Again, we've provided them with the forms. Haven't actually seen the process through yet. In terms of when a purchaser goes through their pre-built inspection, your PDI, I've seen of course clients complain about the project not being done, or you go into occupancy and there's still so many issues and stuff. So I haven't actually seen them in action.
Okay.
But I suspect that people respect that it's there, at least.
Well, at least it's there. Yeah. Thank God for that. Any advice to a purchaser, a buyer that's looking to purchase pre-construction? Personally, right now, I'm not advising clients to, but everyone has their own reasons. You as a real estate lawyer, what would you say maybe is the number one thing to watch out for in the agreement?
Yeah. So when a purchaser is actually specifically in their 10-day cooling off period, you should absolutely be scheduling a call with your lawyer to go over the agreement. The three main things that we look for is the adjustments. Because again, some things that scare people, the one major thing that scares people away from pre-construction is the adjustments that happen on closing. So that is specifically the largest ones are the development charges, your Section 37 charges, and your park levies. We've seen, this was outrageous, but I think 2 years ago, we seen a builder attempt to collect over $100,000 in development charges.
Wow.
Of course, litigators did go after them, but let's say average $20,000 to $30,000 in extra fees on top of your purchase price on closing. And so when we have a first-time home buyer going for a new build, we're sitting down with them and we're actually not just explaining the general nature of new build and the timing and everything, but also the additional costs that they should expect on closing, because sometimes that's a shock.
I could imagine. Some of them are capped, right? Sometimes builders will give incentives.
Exactly, yeah. So if the agent hasn't already done the caps for the purchaser when negotiating the deal, that is what we ask for as lawyers, as well as the right to assign and the right to lease during occupancy. We did have a lot of clients who were promised a great return on investment, and so they unfortunately purchased to assign. And so that's technically why we ask for that permission to assign initially.
And there still will be a fee attached usually to the assignment.
There will be a fee.
What is it usually?
I'd say, again, there's just different conditions. You have to have a certain percentage of your deposits in already. Sometimes it's $5,000 from the vendor, and then you're also covering the builder's legal fees for the assignment. So that can range from $5,000 to $1,500. Yeah. So that's probably the average.
Okay. But it's good to have that option in there.
That option should always be there, again, because even if you are planning to live there, you could also, walk into a situation where you really can't close. Because again, these projects sometimes last 4 years before you're even seeing your occupancy come in, right?
I'm glad you mentioned occupancy. Can we talk about occupancy for a second?
Sure.
So what I always thought was, frankly, bullshit is you need to, if you're in the pre-occupancy period, I guess, or no, I guess we call it occupancy, where you can still live in it, but the building still hasn't been completed 100%. That would be occupancy. Okay. Sorry. So we've seen it where clients, they're surprised because they have to essentially pay to rent their space.
Exactly.
And it's not an option. That's what I always thought was bullshit. If you want to move in, occupancy period, fine, you know what you're getting yourself into. But even if you don't move in, I don't know if it's a standard condition or not, but you still have to pay.
You're required to. Again, builders get away with a lot, but you are required.
Is that new? Because I don't know if I've always heard of that. Or I don't
think so.
It's
for as long as I've been a lawyer, it's always been there.
Okay.
I've seen, someone purchase a condo for over $1 million, and they had to pay $11,000 a month for occupancy. And again, these occupancy periods can be anywhere between 6 to 9 months, especially if it's a high-rise condo. Of course, the periods decrease in length when it's a low-rise.
But is there a legal maximum for how long the occupancy period can last?
So I don't think so, actually.
It can last indefinitely in theory?
Not indefinitely. I honestly haven't actually looked into this. It could have also changed recently.
Sure. Well, I mean, I was being facetious with indefinitely, but no, the point is you could be on the hook for this for, as long as the builder wants you to be, in theory.
Yeah.
So, okay. So that's something to look out for, I guess.
Absolutely.
And that would be in the agreement, obviously. Beforehand or no?
Yes. So when you actually get your agreement, you'll get the Terry-on schedules. Those are your milestone dates.
Okay.
And of course, Terry-on covers any delays that also happen in occupancy as well. So that's something to look out for as well.
But the rental amount will be outlined or will be subject to determination?
Not until you get your interim statement of adjustments.
Okay.
But again, I think it's 3 things that make up your fees. It's the condo fees, it's the interest on the deposit the balance owing, and property taxes. Usually at that point it's not assessed yet, but it's like a prediction.
Rough prediction.
Yeah,
okay.
exactly.
Okay. Yeah, because it'd be nice to know roughly what you're getting yourself into, right?
Yeah.
Okay. Cool. Yeah, that makes sense to me. But I think a lot of people are surprised when they need to make these additional payments. A lot of things are not explained to them. It comes back to communication. Going back to an example, we had a client saying, listen, I mean, we didn't facilitate this pre-construction, but now we're dealing with that mess. So, she was saying, they just pushed me to sign and they didn't care. They just cared about getting the deal done.
Yeah.
They didn't care about what was actually going to happen to me afterwards.
Yeah.
I think that's a big problem in my industry, at least.
Yeah. And I think that's the reason for that 10-day cooling off period, because it's such, a different transaction versus, I guess, resale, that where people need those 10 days to kind of discuss it, consult a lawyer. And I think that's also why I think it's almost being implemented. It should be implemented soon. The 10-day cooling off period for freehold.
Freehold pre-construction?
Pre-construction.
Okay, actually, I was going to ask you that. So the 10-day cooling off period is only for pre-construction condos currently. Mm-hmm. Currently. Okay. Yeah. But it's working on freehold.
Exactly.
Okay. But I suppose the builder could offer it if they like.
Absolutely, yeah. I actually have a deal that just came in and they said contractually they're offering the 10-day cooling off period for a freehold. Because again, they're free to do that.
Right. So just to be, just for people at home, so 10 days cooling off from the date that it was signed. Mm-hmm. Not business days, just 10 regular days. Yeah. 10 days. Okay. Yeah. And you would need to give notice in writing, I'd imagine.
Yes. Okay. Yeah. So that's technically, this is actually an area that hasn't been tried in court, but the way we kind of draft our emails to the lawyers on the builder side, if, for example, there's something that hasn't been included in the agreement, like a development charge cap, we say, we're not prepared to continue with this agreement unless we get X, Y, Z.
Okay.
Now, again, whether that would work in court or not depends.
Okay.
We don't know yet, but we'd hope that it would work that way. But right now, it's not tried and tested.
As a lawyer, what is your general experience about dealing with builders? I guess you're dealing with their legal team. Is that fair to say? Or you're dealing with the builder directly in most cases? No,
we're only legally actually able to deal with our lawyers.
Oh, okay. Depends on the builder.
If I had a choice, I would only do resale.
Okay.
And that is because some of these lawyers that represent these builders, I don't know what time they're living in, definitely not 2024, but they're still asking for physical checks. They're asking for printed documents.
Oh, I see.
Stuff like that. So that's one annoying thing, but that's more on the administrative side. And
there's a lot of things that are antiquated. Even when we do lease deals, they ask for post-dated checks.
Yeah.
Most clients don't even have that.
Yeah, absolutely. Yeah. So we still have clients having to physically deliver their checks.
Do you guys still do faxes?
Yes.
Yeah.
Yeah. We use I think SR fax, which is kind of
like an e-fax.
Yeah, exactly.
Okay.
Yeah. So, but some builders, they don't even give you a phone number or email. It's just a fax.
Oh my goodness.
Yeah.
And they get away with that though.
Sorry?
They get away with that, I guess, yeah.
Totally. And again, that's another popular topic on those platforms, lawyer-only platforms, where people are just complaining about this one particular law firm that deals with builders. It's quite comical. But yeah, I mean, listen, it gets done in the end. Some again, law clerks, all that at those law firms, they understand how annoying it is. So we get them done, but it takes extra work for sure.
So yeah, no, because I'd imagine, because I similar to the real estate industry, there's people that are in it and they're the outside that they view how it should be.
Yeah.
There's memes like what my mom thinks I do, what I think I do, what I actually do, that type of thing. I really like the show Suits. You ever watch Suits?
100%.
I would imagine it's not, your everyday experience is not like Suits.
No.
Okay.
No.
Do you need to be tough? Like, I would imagine you need to put your foot down, but do you need to be, when I think of like a good lawyer, I think of like you're a shark. You understand what I mean?
A good lawyer will be a shark, yes, and they will be a fierce advocate for their clients, but a good lawyer will also know when there is a fight to be had and when there is not.
Okay. That's important.
Exactly. So when, for example, a builder is not budging, you will firstly set your client's expectations, saying, listen, I will take your instruction. I will ask them for a 50% price reduction, but let me set the expectation.
Right.
And say that is very unlikely.
Right.
We had a client saying, listen, I can't close. Can you ask for a mutual release? And we said, we can ask. Very unlikely.
Right.
And we've actually had one scenario where they did sign a mutual release. They said, walk away from your deposit, and that's all we need.
It never hurts to try, right?
Never hurts to try. And I think that's what a lot of lawyers do, saying that they don't even try because it's very unlikely. But it's our job to take our client's instruction, right?
It's true. We do that with offers too. A client wants to lowball. I mean, listen, we advise against it, but at the end of the day, it's your decision.
Exactly.
And you never want to be the one that said no and they go somewhere else and it got done. And now there's a bad taste in their mouth, right?
Yeah, exactly. And we really feel for these clients who are in that situation where they're in trouble, they can't close.
Right.
There's always a scenario where they have family troubles, financial issues. They lost their job, they lost a family member. And so a lot of the times we do ask for sympathy from the builder. Sometimes it works, sometimes it doesn't. But it's, again, setting those expectations that
of course
goes a long way.
Could you explain the process, any difference in process with a bank foreclosure or a power of sale? I don't know if those are two different things or just synonyms. Because I know there are a lot of buyers. We have a lot of buyers that want a deal, especially in this market with high interest rates, high prices. They want a deal, so they go to, bank foreclosure, that type of thing. They think they're going to get a deal. What are some things to is the process relatively the same? Is it different?
It's the same.
It's the same.
It's the same. It's totally the same. Even banks will hire their own agents, so it's kind of like you're still dealing with an agent on the other end. Right. And then,
do you have is there any risk of, because a bank foreclosure happens when the original purchaser can no longer afford to make the payments on the mortgage? That's correct. So the bank assumes title of the property.
Yeah.
Is that usually how that goes?
Yeah. So again, it depends on what part of the process they're in. But technically speaking, if you miss a payment or two, they'll send you a letter. Right. Notice of sale. Then there's 35 days to remediate that. And then the bank starts to move in. But from the time that you default, and them actually taking possession of the property is a couple months. Okay. So usually the property gets sold within that time. Okay. But afterwards, again, it's a long process. But does the new buyer ever have to be worried about the previous owner trying to move back into the property or try and practically
get money
maybe?
out of
There's
them,
not anything them physically stopping them visiting the property.
But legally, the title. When we get to the point where you're buying it as a bank foreclosure, and is there a difference between bank foreclosure and power sale, or is it the same thing essentially?
Similar in process. Sometimes there's legal differences, but subtle differences.
Okay. Yeah. But by the time we get to that process, the legal title has been transferred to the person holding the mortgage.
Yeah.
Okay.
Yeah.
Okay. The mortgage or
the lender. Yeah.
The lender. Okay. Yeah. Okay. So then it would be just like a normal deal.
Pretty much, exactly. For all intents and purposes, yeah.
Okay.
Totally.
Okay, cool. Do you guys deal with those or not too much?
Recently we've actually dealt with that on the seller side. We've unfortunately had clients where the sale price doesn't actually cover all the mortgages. Yes. And so that's actually sometimes we advise agents to be very careful when they're having a listing. Go on Geo Warehouse, click that button that says parcel register and pay the $30 and make sure that the price that you're setting it at will cover the mortgages on the property. We had a situation where a client had, a last minute private mortgage where essentially the encumbrances were way more than the sale price.
Oh, wow.
And so what we had to do is we had to go to that second lender to then agree to this purchase price, because then it's at the end of the day, the second lender is who's taking the haircut.
Right. The first lender is king.
Exactly.
Right. Yeah. They're always made first.
Exactly. Because again, if you accept those agreements and you come to closing and that second lender doesn't agree to discharge, then you're kind of in trouble. You can't close. So there's conversations to be had in those scenarios, and unfortunately, I've had two over the holidays.
Oh wow.
Yeah.
That's rough.
Yeah.
So the repercussion for agents, 'cause I know some agents listen to this too, you would not get paid your commission.
It depends, because there's actually a benefit to actually having a lawyer on the team.
Sure.
When you're making those transactions, because what we do technically as lawyers too is we go up to that second lender and we set up the math for them.
Okay.
And we're the ones that say commission has to be paid.
Okay.
Because again, if for example there is a scenario where it isn't sold in time and the first lender takes position of the seller, they don't care how much the second lender gets.
Right.
And commission is payable, property tax arrears are payable, and so the agents get the commission anyways.
Oh, okay.
Yeah.
From the first lender.
From the sale proceeds.
Oh, from the sale proceeds.
Before the second lender gets there.
Oh, before the second. But the primary lender gets paid above everyone.
Not necessarily.
Not necessarily.
Property tax arrears and commission, I think, are up there as well.
Oh, commissions would supersede them?
That actually I'm not sure about, but I know that commission is not necessarily at risk, but it's good to have that conversation.
Okay.
Before you accept a deal.
So there may be a business case then for a listing agent to take a deal like that. And
there's agents that are starting to specialize in that because seeing as how many people are foreclosing on their properties. Yeah. There's deals to be had there too. If you're approaching those wealthy private lenders who they're seeing a lot of their borrowers default.
Right.
There's an opportunity there for sure.
Yeah. So you've seen an increase in the amount of defaults? Unfortunately.
Yeah.
Has it was 2024 the worst year for that in your opinion, or
so far?
How's
Who knows?
How's it looking this year so far? I know it's only January.
I mean that one deal that we had in December, it's kind of flowing into this year, but I suspect we're going to see more.
Okay.
Because again, a lot of these mortgages are coming up for renewal.
Yes.
Right.
Yes.
So who knows what we're going to see?
Yeah, it's a concern for everyone, especially even now we have today. President Trump is being inaugurated, so there's some threats on tariffs and what our economy is going to do. Hopefully, there's no tailspin. I think things will be okay, but there might be some growing pains. But I think everyone's a little bit on edge rather. But we have another interest rate announcement the 29th of January, so we'll see where the Bank of Canada goes there. And I guess we'll have to, we're always.
Yeah. What's your prediction?
If they're going to increase or not?
Yeah.
I think they might hold. I think we had better job stats last month than anticipated. I think the unemployment edged down a hair, if I'm correct. With that being said, though, things are still very unaffordable.
Yeah.
I just don't think. I'm not convinced that the interest rate is going to solve that problem, even if it went to zero.
Yeah.
It would probably make it worse.
Yeah.
We are just not focused in this country on solving the actual problem, in my opinion, which is this is a supply issue. We just don't have enough homes. We're not going to build enough homes, even if we scale back.
And the right homes.
And the right homes, yes.
Yeah. We see, I mean,
you don't want a 200
lots of
square foot
inventory.
shoebox.
Exactly. I recently saw on TikTok, someone was selling a place less than 500 square feet for 700,000.
Oh, yeah.
And a lot of the inventory is, it's not suitable for families.
No,
right?
it was
It's
geared
always
towards
been
investors.
exactly.
Yeah. And in the hot market, everyone was, I heard stories of agents paying other agents that had assignments. I'll give you 20,000 from my commission if you just get me in line. Like there was such desperation. People were going nuts just to get their hands on these things and not even looking at the layout. Especially when you buy pre-construction, you only have the layout to go off of, right?
Yeah.
We walk into these things all the time. You walk in, you walk out. Like our podcast studio room is bigger than most one-bedroom condos, unfortunately.
How crazy.
Yeah, it's crazy. So if you were in the market for a property, what would you buy?
Probably like a really old, dilapidated freehold house.
Okay, and fix it up.
Okay,
I think that's the move. Yeah.
Yeah, I don't think I'd be looking for a turnkey property.
Right.
Again, I have a really specific taste. I also think there's a premium on those properties
Of
where
course.
the increase in value wouldn't be realized for at least a couple of years.
No,
I have specific taste. I want a project.
No, it's good, and it'd be smart to do so because no longer are the days where people actually want to put in the effort into the property. They do want that turnkey.
Yeah, I get that. I get
a lot.
both sides. Yeah.
Yeah, we see that a lot. I mean, if you're looking for top dollar as a seller, you want it to be turnkey. But as a buyer, as a savvy buyer, you want to look for those hidden gems.
Exactly.
Yeah.
Good location and potential.
Absolutely.
Yeah.
Absolutely. Just kind of winding down here. Because you're a real estate lawyer, first and foremost, we have a nice partnership here at Remax West with you. I think you're a fantastic lawyer. The dealings that I've had with you, I want other agents to use you as their lawyer. So what kind of, what would be your advice? Because there are some agents that listen to this. What would be your advice to agents that are looking to, have you involved in the listing, on the selling end, the buying end, any kind of general words of advice for them? On a
Nothing
legal
other
side
than
of things.
keep me on speed dial.
Keep you on speed dial.
Keep me on speed dial. Again, we love working with clients too, but the relationships also come from agents as well.
Yeah.
And when we improve the work of agents, we improve the work for clients and the quality of these files. So just be careful with those unique clauses that you're drafting in your Schedule A's, and check title. Please buy the registered parcel for $30 on Geo Warehouse. It would it's part of your responsibility, but also it'll save your clients a lot of headache too.
Well, we have a lot of, our industry has a lot of agents that it's kind of a race to the bottom for some agents in terms of listing. So they're listing the property for 1%, sometimes a flat fee. So it's not in their business model to afford that package, which I think is wrong.
Yeah.
But I think that's another reason to sell yourself better, to fight for your commission.
Completely.
If you can't negotiate your commission, guys, you can't negotiate the sale of their home. It's just obvious. I don't understand why some people don't realize that, but at the end of the day, it depends on the situation, but it usually always pans out that way, unfortunately.
I know. I was actually at a meeting recently at Remax West, and they were saying, agents, you're not selling the properties, you are selling yourself.
Yes.
MLS sells the property.
Yep.
You have to sell yourself.
Exactly. And actually, we just changed with the new TRESA rules in our Schedule A of a listing agreement. And even in the buyer representation agreement, you need to outline that Schedule A, at least 3 items, I believe, what services you're going to outline for the client.
Yeah.
And when I first did it, I almost had, I had trouble manifesting it into words because we do everything and anything. I honestly wanted to put this like anything and everything to protect and promote the client's best interest.
Yeah.
And I think that's an umbrella because every person's situation is different.
100%.
Every situation, dynamic, if it's a divorce, if it's just, of upsizing, downsizing, there's always individual personalities. There's always something extra.
Yeah.
I think I do something different for every client. So it's really hard to put that into words, but that takes, you're selling yourself, to your point.
100%. And I think that's what is also missing in the legal industry as well, is that client satisfaction, and just the business side of lawyering as well. It's it's few and far between those lawyers that actually care about that.
Right.
So, and I'm sure it's same with agents too. They love the money that comes out of it, but it's also the clients that'll get you further.
Absolutely.
Remember?
And I think I can speak for both of us, but we like to have clients for life.
Yeah.
We want to foster and nurture that relationship. We don't want a one and done. We don't want to screw you over to get paid short term, and then in the long term we're missing out on all the other business referrals, XYZ, that could, run downstream of that.
Yeah.
So yeah, I think we're on the same page with that. So.
Absolutely.
Awesome. Thank you so much, Alex, for coming in today. Just one more plug for your business. What was your business name again? How agents can get in contact with you, how buyers and sellers can get in contact with you.
Yeah. So the firm is legalclosing.ca.
Okay.
That is the website. So feel free to reach out to us. My number is there.
Okay. So they can reach out to you directly.
Exactly. Yeah.
Okay. On the website. Awesome. Thank you very much. Thanks for joining us. Like and subscribe. Goodbye, everybody.
Thank you.